In which one of the following category an opinion contained in the book of deceased expert which is produced in evidence of the court put under section 32? Which subsection of section 32 of the Indian Evidence Act make the fact of relation the parties who are not alive are relevant? Subsection 5 होना चाहिए subsection 1. In which one of the following the dying declaration is not relevant? When the declarant in his declaration speak about the circumstances which lead to the death of other person. Queen Empress versus Abdullah is a leading case on dying declaration. Which provisions of Indian Evidence Act deal with dying declaration? Section 32 clause 1. A statement to become relevant under section 32 clause 1 of Indian Evidence Act as dying declaration should have been made under which one of the following circumstances? It should be in the relation to cause the death and circumstances of the transaction as resulted in his death. A dying declaration is admissible evidence. Its admissibility is found upon the principle of necessity. Which one of the following case related to dying declaration? Queen versus Abdullah. Which of the following statement is correct for admissibility of evidence under section 32 clause 1 of Indian Evidence Act? Dying declaration may be verbal. A statement made in anticipation of death by a person who survived to police officer would be inadmissible. Immediately before dying declaration, sign gesture made by victim whose throat was cut by the accused in the answer to the question indicating the person who would him are admissible under section 32. A dying declaration recorded by the police officer in the form of FIR the death of the author without obtaining certificate to his mental fitness can be treated as a dying declaration. About 6 months before he was murdered, the deceased wrote a letter to SP Jabalpur asking for protection and stating that he apprehended injury from A and was in the fear of his life. The letter was admissible under section 32. Under section 32 of Indian Evidence Act, a statement of a person who is dead is relevant if it relates to the cause of his own death. A statement of a person who is dead is relevant fact under dash of Indian Evidence Act, section 32(1). The statement of the dead person are relevant under which provision? Section 32 clause 1. Which one of the following will be an inadmissible dying declaration? None of the above. Under section 32 of Indian Evidence Act, a statement of a person who died or be admissible must be related to the cause of his own death. The deposition relevant under section 33 of Indian Evidence Act, but the subject to the control of section 158 of Indian Evidence Act. In a suit after the examination, the cross-examination, and the suit after the examination and the cross-examination of witness, the plaintiff was returned for prosecution to the court of competent jurisdiction. Before proceeding stated in the court, the witness died. His deposition is admissible under section 33. Relevant entries in the book of account alone are sufficient to charge any person with liability. SUB for 1000 and shows entries in his account book showing B to in debt to him this amount. This entry is relevant. Whether a party can be proved entry made by itself in the book of account Yes. A sue B for rupees 1000 and so entries in his book of accounts showing B to indebt to him to this amount. Under Indian Evidence Act, the entries are relevant but not sufficient without other proof of debt. C is employed by a cashier by the firm to receive money and its sale counter. It is his duty to make entries in ledger showing the amount received by him. He is prosecuted on the charge of criminal breach of trust respect of the rupee 90,000 on the basis of the evidence showing by him made in the entries shows that he had received rupees of the 10,000 only, whereas he has actually received rupees 1 lakh. C has taken the plea that wrong entries was accidentally or unintentionally. The fact the other entries made the same ledger are false. Each showing receipt is less amount by C is relevant and it has been bearing on the question of intention. Entries in the book of account regularly kept in course of business is admissible under section 34 of Evidence Act, irrespective of whether they themselves create liability or not. Which one of the following section of Indian Evidence Act deal with the relevancy of a statement as the law contained in the law book? Section 38. In which one of the following section of Indian Evidence Act has been substituted for old section by Information Technology Act 2000? Section 39. Under which one of the following section of Indian Evidence previous judgment as to relevant to the bar of the second suit or trial? Section 40. Section 40 and 44 of Indian Evidence Act deal with the relevancy of judgment decree orders. The principle of res judicata is provided in which one of the following section of Indian Evidence Act? Section 40. A prosecute B for adultery with C's wife. B denies that C is A's wife, but the court convict B of adulteries. Afterwards, C prosecuted for bigamy in marrying B during A's lifetime. C said that she was never A's wife. Under Indian Evidence Act, judgment of B against is irrelevant. A prosecutes B for adultery with C's wife. B contested denying the allegation. B was found guilty, the convicted in the case. Subsequently, C was prosecuted by charge of bigamy on allegation C had married B during substance of her marriage, and A contest by denying that C was ever married to A. In this case against C, judgment is in the first case against B is irrelevant. What kind of jurisdiction is not mentioned under section 41 of Indian Evidence Act 1882? Revenue. The presumption under section 41 of Indian Evidence Act is irrevocable presumption of law. Presumption under section 41 of Indian Evidence Act is irrevocable presumption of law. Under Indian Evidence Act, the judgment of Admiralty Court is relevant under section 41. In which one of the following judgments is irrelevant under section 43 of Indian Evidence Act, judgment of criminal court? Disputed handwriting can be proved by calling an expert, by examining a person acquainted with the writing and writer of the question of document, comparison of two admitted and disputed document. An expert under Indian Evidence Act is a person having requisite skill on the matter upon which he is given upon. The opinion of expert is relevant on the point of Indian law. Under which section of the Indian Evidence Act the expert is relevant? Under section 45. Which one of the following is not a statement about the expert opinion? Expert opinion is binding on the judges always. Which one of the following statements is correct? The court takes the absence of expert when it has to form an opinion on point of Indian law. The following is not an exception of rule of hearsay. Medical expert opinion. Who amongst the following is the expert under Indian Evidence Act? Handwriting expert, fingerprint expert, ballistic expert. In which section of the Indian Evidence Act opinion of third person is relevant? Section 45. Which one among the following does not fall into the category of expert evidence? Opinion by narcolepsist about the conduct of the mind, condition of the mind. Opinion of an expert under section 45 of Indian Evidence Act is supportive and corroborative in nature. Opinion of handwriting expert can be acted upon without corroboration. Under which section of Indian Evidence Act DNA test can be admitted as evidence? Section 45. Under which section of Indian Evidence opinion of expert is relevant? Section 45. Under the provision of section 45 of Indian Evidence Act, the opinion of expert can be for identify the finger impression, identify the handwriting. Expert is a student may be treated as an expert under section 45 of Indian Evidence Act 1882. It was laid down by Supreme Court in Kanpur University versus Shimed Gupta and others 1983. Under section 45 of Indian Evidence Act, which one of the following have not been mentioned as a point of the opinion of the expert is irrelevant? Point of domestic law. Opinion of an expert under section 45 of Indian Evidence Act is not conclusive proof. An expert is competent to testify which one of the following? Matter of sign, question of act, foreign law. Opinion of the expert is not relevant upon the point of domestic law. When the court has to form the opinion as to electronic signature as any person, the opinion of the clarifying authority which has issued the electronic signature certificate is relevant fact. Mark the incorrect statement. Court may take the assistance of the expert forming an opinion as to the point of not foreign law, not art. A disputed handwriting can be proved by calling an expert, examine a person acquainted with the handwriting of the writer of the question document, comparison of two admitted and disputed documents. Which among the following does not fall into the category of evidence? Opinion of narcolepsist about the condition of mind. Which one of the following statement is not correct? Court can take assistance of expert if he had to form an opinion about the point of Indian law. Under which section of Indian Evidence Act expert opinion is relevant? Section 45. When the opinion of expert is relevant in all of the above matter. When the court has to form the opinion of science and art, when the identification of handwriting impression is to be decided, when the opinion has to be formed upon the point of Indian law. B, C, D never saw A writing, but they have their opinion about the handwriting of A. The opinion of which one is relevant? All of these. Of B, because B is a merchant in Delhi, A has written many letters addressed to him. Of C, because C is a clerk's duty was examine the file and a correspondence. Of D, because D is a broker who have habitually submitted a letter prompting to be written by A of his advice. Under which section of Indian Evidence Act an expert opinion is relevant? B. Section 45. Under Indian Evidence Act, the subject matter of which opinion of the expert is relevant are foreign law, science, finger impression. The question is whether a certain document was written by, in this case, which one of the following is relevant? The opinion of the expert on the question whether two documents were written. The opinion of the expert on the question whether any two documents were written in different persons. Opinion of the expert is relevant under which one of the following section of Indian Evidence Act? Section 45. Relevancy of expert evidence for the purpose of Evidence Act is contained in section 45 to 48. Answer with the help of code. Handwriting may be proved by evidence of writer himself, opinion of expert, evidence of person acquainted with the handwriting, quote under section 73 of Evidence Act. A person suffering from mental disorder can be exempted from such liability on proof of expert evidence on this effect. Opinion of expert is relevant under section 45 of Evidence Act. Following is the no exception of the rule of hearsay. Medical expert opinion. Expert opinion is relevant under section 45 of Indian Evidence Act, which when it was given on a point of foreign law. Expert opinion is relevant under that section of Indian Evidence Act, section 45. Which one of the following provision of Indian Evidence Act 1872 deals with the relevancy of opinion of expert? Section 45 and 46. The opinion of the examiner of electronic evidence is a relevant fact under which provision of Indian Evidence Act? Section 45A. Expert opinion under section 45 is supportative and corroborative in nature. Res inter alias actus is receivable under section 46 of Indian Evidence Act. Facts supporting or rebuting the opinion of expert are relevant under section 46 of Indian Evidence Act. Where the handwriting of teacher is in question, the opinion of principal may be relevant under Indian Evidence Act. Section 47. Under which one of the following section of Indian Evidence Act opinion as to digital signature has been considered to be relevant? Section 47A. Under which one of the following section of Indian Evidence Act opinion as to digital signature is relevant? Section 47A. An expert may give an account of experiment performed by him for the purpose of forming his opinion under which one of the following section of the Evidence Act? Section 51. In respect of the digital signature, which one of the following is relevant? The court may direct the certificate of certifying authority may be produced in court. Where in judicial proceeding the handwriting of a teacher is in question, the opinion of his or her student shall be relevant under section 47 of the Indian Evidence Act. Which one of the following section of Indian Evidence Act deal with the relevancy of opinion as to digital signature? Section 47A. Where the court has to be formed as the opinion of electronic signature of a person, the opinion for certifying authority which has issued the electronic signature certificate is relevant fact. The right of the villagers of a particular village to use the water of particular well in general custom or right within the meaning of one of the following section of Indian Evidence Act, section 48. Which one of the following section of Indian Evidence Act makes the opinion as to existence of custom, section 48. The relationship in section 15 of the Indian Evidence Act means relationship by blood or marriage or adoption. Which one of the following section of Indian Penal Code is expressly excluded by the proviso of section 50 of Indian Evidence Act 1872, 497? Under which section of Indian Evidence Act the opinion relating to the relationship is relevant? 50. According to Indian Evidence Act, which among the following is irrelevant? Evidence of good character to prove the imputed conduct of civil cases. Evidence are adduced by the party to the suit about the character as per the provision of Indian Evidence Act. Which one of the following are correct? Evidence of character in civil proceeding is irrelevant and inadmissible. General, the character of evidence is admissible. It affects the amount of damage which he ought to be received. Character of a person for the purpose of the law of evidence is not relevant in which one of the following section? Character to prove conduct and imputed in civil cases. Which one of the following statement is correct? Evidence of a character in civil cases is irrelevant. Evidence of good character is relevant in criminal cases. Under which one of the following section of Indian Evidence Act previous good character is relevant in criminal cases? Section 53. In criminal cases, the fact that person accused is of good character is relevant fact. In criminal proceeding, the fact that person accused is of good character is relevant according to the section 53. In criminal case, good character is relevant under which section of the Indian Evidence Act? Section 53. Whether in criminal proceeding the previous good character of the accused person is relevant? Yes. Which one of the following statement is not correct? In criminal case, previous good character is irrelevant. In criminal proceeding, under which one of the following situation the fact of the accused person is bad character is relevant? Where the character of the accused is in issue, where the court is satisfied. The rebut prior evidence of good character. In criminal proceeding, the fact that accused person is a bad character is above A is correct, irrelevant, unless evidence has been given that he has a good character. Which one of the following statement is not true? In criminal proceeding, the fact that the accused has a bad character is irrelevant. In criminal cases, previous bad character of accused is relevant when evidence has given that he has a good character and when the bad character is itself in issue. In criminal cases, previous good character of the accused is relevant. Character of a person for purpose of law of evidence is not relevant in which one of the following section? Character to prove the conduct of imputed in civil nature. By which one of the following section amendment of section 53A has been inserted in Indian Evidence Act? Criminal Law Amendment Act 2013. Which one of the following statement is not correct? And in rape trial, evidence of previous sexual experience of the victim is relevant is not correct. Which one is correct? In rape trial, evidence of previous good character of accused is relevant. In rape trial, evidence of character of the victim is not relevant. In criminal proceeding, the fact that the accused person has a bad character is irrelevant. Above A is a right unless evidence has been given as a good character. A person is prosecuted for theft. Evidence is sought to be produced to prove that person is a bad character and suspect of the theft on several occasions in past. The evidence was not admissible. Under which section of Indian Evidence Act bad character of an accused is not relevant? 54. Under section 54 of Indian Evidence Act, previous bad character is irrelevant but became relevant if none of these. The term character as explained in section 55 of Indian Evidence Act 1872 means reputation and deposition of general nature. Character as affecting damage has been discussed in which one of the following section? Section 55 of Indian Evidence Act 1872. Relevancy of fact contained in Section 5 to 55 of Indian Evidence Act. Which one of the following is true statement in relation of relevancy of character? In civil case, character of any person affecting the amount of damage is relevant. The statement in order to constitute a confession under Indian Evidence Act must be either admitted in term the offence or at any rate of substantially or fact which constitute the offence. The above view was expressed by the Privy Council in which from the following case, Pakla Narayan Swami versus King and Trade. Palvinder Kaur versus State of Punjab is related to which one of the following? Confession. In which one of the following cases the Supreme Court held that the confession of co-accused are very weak evidence and no conviction can be based on solely on such confession? Kashmira Singh versus State of Madhya Pradesh. In criminal cases, fact that accused is of good character is relevant. Relevancy and admissibility under Indian Evidence Act 1872 are neither synonymous nor coextensive. The question between A and B is whether a certain deed is or is not forged. A affirmed that it is genuine, B that it is forged. A may prove the statement by B that deed is genuine and B may prove the statement by A that deed is forged. Confession can be result of self-talk communication and confession to the another person is not necessary. Was held in the case of Saho versus State of UP. Good character of person is relevant under criminal proceeding. True. Retracted confession cannot be made a sole basis of conviction unless the same is corroborated. Mark the incorrect statement. D. Correct statement that evidence is always allowed of facts which are necessary to introduce the main fact of the some relevant fact. Evidence can be given of the fact which support the rebutable inference suggested by the fact in issue or relevant fact. Fact which is contradict the inference of the guilt which is also relevant. A is accused of murdering B. The fact that A constructed in the case is an hour before the murder, A took B in his car in the certain places. A along returned home. A cloth were found to be blood stained. The evidence of which takes into account of the above mentioned fact is called circumstantial evidence. Which one of the following statement is correct? The latest approach toward the evidentiary value of identification period is laid down by Supreme Court in Anik Kumar versus State of UP is that evidence to support or rebut any fact before the court of criminal proceeding. What does the Police custody in context of Indian Evidence Act 1872 means some kind of surveillance and restriction by the police. Noor Mohammed versus Imtiaz Ali, section 6. Pratap Singh versus State of Punjab, section 7. Sardul Singh versus State of Bombay, section 8. Raghunath versus State of UP, section 17. Admission by person having any proprietary interest, section 18. Confession made by after the removal of impression caused by inducement, section 28. C is wrong. Confession of an accused in police custody, section 26. In criminal proceeding, good character of accused is always relevant. The previous conviction of the relevant is relevant as to the evidence of bad character. Which one of the following piece of evidence is not relevant under Indian Evidence Act? C. Which one is relevant? A is tried for murder of B. The evidence is given that A murdered C, that B knew that A had murdered C, and that B had tried to extort money from A by threatening to make his knowledge public. The A sue B upon the bond for the payment of money. B denies the payment of the bond. Evidence is given that B required money at the time of the bond. A tried for the murder of B by poison. Evidence is given before the death of B. A procured poison in the similar to that which was administered to B. Which one of the following piece of evidence is not relevant under Indian Evidence Act? D. A is accused of fraudulently delivering to another person a counterfeit coin which knew to be counterfeit. Evidence is given that he was also in the possession of the counterfeit coin. A sue for the damage done by B's dog which he knew that for his sheesh. Evidence is given that excluded is given that the dog is previous beaten X, Y, Z, and that they had made complaint to B. A is charged with shooting at B with intent to kill him. Evidence is given that A has previously shot B. In certain cases, corroboration of the confession is necessary. In all cases, extrajudicial confession must be corroborated. Confession caused by inducement, threat, promise. Pyarelal Bhargav versus State of Rajasthan. Confession to custom officer, State of Punjab versus Barkatram. Confession in the FIR given by the accused, Agnu Negesia versus State. Discovery of fact pursuant to the statement in police custody, State of Bombay versus Kathi Kalu Ojha. Which one of the following pair is not correctly matched? B is not correctly matched. Which is incorrectly matches? Relevancy of statement as to the law contained in law book, section 38. Relevancy of containing evidence for proving in subsequent proceeding the truth of the fact stated therein, section 33. Relevancy of a statement as a fact of public nature, section 37. By Information Technology Act 2000, amendment made in all of these, section 17, 34, 35. Which statement is not correct? C. Which one is correct? Are some facts are relevant but not admissible, some facts are admissible but not relevant, all admissible fact is not relevant. Under Indian Evidence Act 1872, prosecution or complainant may ask leading question to his own witness with the permission of the court. Case Pakla Narayan Swamy versus King Emperor is related to Section 32, Clause 1 of Indian Evidence Act. A and B were prosecuted for conspiracy for bribing a police officer. A came to the police station and offered an inspector a packet of currency note. He told that inspector that B had sent the money as consideration for hushing up the case against him. The offer of the money and accompanying statement made by A were relevant against both A and B. Admission by agent are admissible in civil proceeding only if the agent has authority to make admission, not admissible in criminal proceeding. A dispute of handwriting can be proved by calling an expert, by examination of person acquainted with the handwriting or the writer of the questioned document, by compromising of two admitted and disputed. Which one of the following is not fact admitted? Fact which is inconsistent by the fact opposite. Which one among the following cases of Supreme Court of India said that it is not absolute rule of law that dying declaration must be corroborated by other evidence before it can be acted? Kausal Rao versus State of Bombay. The following is not an exception to the rule of hearsay. Expert opinion. Which one of the following is not a case of dying declaration? C. Sitaram versus State of UP. Which one is the case of dying declaration? Ratan Gadu versus State of Bihar. Paniben versus State of Gujarat. Kausal Rao versus State of Maharashtra. In which section of the Indian Evidence Act the word to form part of the same transaction are provided? Section 6. The question is whether A is ravished. Instead of making any complaint, C said that she has been ravished. 2 is relevant, but it is not relevant under Section 8 of Indian Evidence Act. Choose the correct preposition. Evidence or fingerprint expert can be used only corroborated as some item of substantial evidence which is otherwise on record. Evidence of fingerprint expert is admissible in all circumstances except evidence. A co-defendant in case can be cross-examination by other co-defendant when their interests adverse to each other. Hearsay evidence is generally inadmissible. However, in which one of the following cases it may be admissible? Res gestae, admission and confession, dying declaration. Which is final order decree of criminal of a competent court among the following is a judgment in rem, in exercise of matrimonial or insolvency jurisdiction. During the course of investigation, information received from an accused who is in the police custody lead to the discovery about arms, cloth, ornament, corpus which are related with offence are relevant under Section 27 of Indian Evidence Act. The principle is laid down in which case? Pankhuri Kotya versus Emperor. Res gestae is literal meanings, same transaction. Identification of accused through his photograph is admissible in evidence. Exception to the rule against the admissibility of hearsay evidence are provided under Section 6, 32 and 34. Confession is admissible if it is made by the accused to a spiritual advisor under inducement of good of his soul. Which one of the following is correct in respect of determining the death of the A? A letter from a deceased father to a friend announcing the birth of A is relevant fact. Which of the following statement is given below is correct? In civil case, the character to prove the conduct imputed to the party is not relevant. In criminal proceeding, bad character of the accused is not relevant unless evidence is good character has been given. In criminal proceeding, previous conviction of the accused is relevant as to the evidence of bad character. Which one of the following statement is correct? The confession of the accused made while in custody of a police may be proved if the consequence of information received thereby it is relevant fact discovered. Which of the following is incorrect under Evidence Act? In a case where A is tried for murder of B, the intentionally shooting him death, the fact that A was a habit of shooting the people with intent to murder them is relevant. Which one of the following is not correct statement? No confession which is procured promise is relevant. Extrajudicial confession means confession made by to the police officer. A statement of a person who is dead or cannot be found is not relevant when it is in the favor and the interest of its maker. Identification period can be held by magistrate only. In which one of the following cases Supreme Court held that any information or material that subsequently discovered with the help of voluntary administered test result can be admitted in accordance with the section 27 of Indian Evidence Act 1872. Selvi versus State of Karnataka. The report of medical officer is stating the injury of victim is relevant and admissible evidence. Admission made by a party are evidence against prejudice of estate. Under Indian Evidence Act 1872, relevant fact must be legally relevant. R.K. Malkani versus State of Maharashtra is related to relevancy of fact forming the same transaction. In which one of the following case it is the character of person is relevant? Criminal cases only. A prosecuted B for the adultery with C's C. A's wife B denies that C is A's wife, but court convicted B for adultery. Afterwards, C prosecuted for bigamy in the marrying B during A's lifetime. C says that C was never was A's wife. Which statement is correct as per the Indian Evidence Act? The judgment against B is not relevant against C. Extrajudicial confession is voluntary and can be relied upon the evidence. Extrajudicial confession is a weak piece of evidence. Both are right. Paklan Narayan Swamy versus King Emperor is related to dying declaration. Fact as a effect of the fact in issue, section 7. Fact forming the part of same transaction, 6. Fact which constitute the preparation of any fact in issue, 9. Fact necessary to explain the inducement, fact, 8. Which one of the following section of Evidence Act said that confession caused by inducement threat promise is irrelevant? None of these. Which one of the following statement is correct? Admission can be oral or documentary. Admission and confession are exception to hearsay evidence. Form relevant evidence admitted in evidence of proof. Relevancy and admissibility under Indian Evidence Act is neither synonymous nor coextensive. Admission according to Indian Evidence Act includes the statement by expressly referred person, agent of a party proceeding authorized to make the statement, person whose liability must be proved, person from whom the party derive the interest in the subject matter. According to Indian Evidence Act, which among the following is irrelevant? Indian evidence of the character to prove imputed conduct in civil cases. A court cannot compel a party to undergo a birth test to establish the legitimacy of child because it would amount to the declaring the mother unchaste and child illegitimate. The view laid down in which one of the following case? Nigamma versus Chikiya. In which one of the following is a judgment in personam, a final judgment, a suit of restitution of conjugal right. An admission can be used against co-defendant. Section 46, fact bearing upon opinion of expert. 47, opinion digital signature. 47A, 47 is handwriting when relevant. 47A, opinion digital signature. 48, opinion extensive of the right custom when relevant. A confession is always goes against the maker of it, provided it has been made fairly and voluntary. When a married woman dying of burning, when was a person of unsound mind and the medical certificate vouchsafed her physical fitness for the statement and not the state of mind at the crucial moment in which one of the following statement of the court said that a statement could not be relied upon. Ukka Ram versus State of Rajasthan. In criminal cases, the fact that accused of the good character is relevant. Evidence of custom cannot be given to establish criminal right. Confession can be result of self-talk communication. Communication of confession to another person is not necessary was held in the case of Saho versus State of UP. Whether evidence of non-existence of the fact in issue may be given, yes. In the trial of a murder of B by A, which fact is not relevant as the following. A borrowed a rupee 10,000 from B. Without appearing before the court, a statement of some person in certain circumstances mentioned in section 32 of Indian Evidence Act are considered relevant. Who among the following is not included in the category? Who is not willing to appear in the court? Who is relevant? Who cannot be fired? Who has become incapable of giving evidence? Who attendance cannot be procured without delay? All the admission are confession, but all the confession are not admission. The statement is incorrect. Which one of the following is not a leading case of dying declaration? Deep Chand versus Rajasthan. A is being tried of robbery with B. A was found in the possession of B's watch just after the robbery. Which one of the following fact is relevant? That A was seen wearing the watch before the robbery. Which one of the following is a leading case of entries in the book of account when relevant? Alke Advani versus CVI. Which one of the following is a leading case on the confession of person in authority? Pyare Lal Bhagwan versus State of Rajasthan. Confessional statement is made by the conspirator after they were arrested impacting other co-conspirator. As regarded admissibility of the statement, which one of the following is correct? The statement is inadmissible because the common intention was no longer existed and held in the parliament attack case. In which one of the following cases was the constitutional validity of section 27 was upheld. State of UP versus Deepman Upadhyay, in which case Indra Mohan Goswami and another state of Uttaranchal and others, the Supreme Court held that non-bailable warrants should be issued only when the summon or bailable warrants should be unlikely to have been desired result bringing a person to the court. Mode of proof of custom contained in 32 clause 4, 32 clause 7, 48. Extrajudicial confession is voluntary, can be relied upon other evidence. Extrajudicial confession is a weak piece of evidence. Which of the following statement is incorrect as per the provision of Indian Evidence Act? Whenever the opinion of any living person is relevant, the ground which such opinion is based is irrelevant. Extrajudicial confession made by the accused of Kotwar is admissible in evidence was laid down in the full bench of Madhya Pradesh court in case of Anni alias Ramesh versus State of Madras MP, in which case section 27 was held to be constitutionally valid. Deepman Upadhyay versus State of UP. The case of Kashmira Singh versus State of Madhya Pradesh is related to confession of co-accused. State of UP versus Deepman Upadhyay is concerned with confession. Conduct of an eyewitness is not disclosing the incident of anybody for number of days highly unnatural. One of the sufficient is rejected the testimony of ground of rejection of testimony of eyewitness. Necessary rule as to the admissibility of evidence is applicable when the maker of the statement is dead or became incapable of giving evidence, is a person who can be found has attained such attendance can be procured without unreasonable delay and expenses, is such person cannot be found. In DNA test, the DNA test cannot be rebutted. The conclusive presumption envisaged under section 12 of Indian Evidence Act, the party can avoid the rigors of such conclusive presumption only by the providing non-access, which is negative proof. It was so held in which case? शेख फारुद्दीन वर्सेस शेख मोहम्मद हुसैन 2006. A prosecuted B for stealing a cow for him. B is convicted. A afterwards sues C for the cow which he sold to him before the conviction. The judgment against B is irrelevant as between A and C. A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which is administered to B is relevant. The question is whether A was ravished. As a conduct of the fact that without making a complaint, she said that she was ravished is not relevant. Telling his wife that P's wife had called him to receive payment due to him, K leave his house. After 2 days, his dismembered body is found in the trunk. In P's trial for murder K, the statement made by K wife is admissible as it relates to the circumstances and transaction which result to the K's death. Section 7, cause of relevant fact. Section 8, motive of relevant fact. Section 11, fact inconsistent with the relevant fact. Section 14, fact showing the existence of any state of body.